Welcome back. We're still following the Timothy Jones case. They're on their lunch break for now. But we have a new case coming up for you on Monday. Here's our very own Rachel Stockman with the update.
A murder for hire? An ex-lover jealous enough to pay for a hitman? Prosecutors say Brenda Delgado plotted for months to kill her former boyfriend's new girlfriend. Kendra Hatcher, a prominent Dallas dentist, was found shot to death in a parking garage on September 2nd, 2015. Delgado allegedly promised to pay hitman Christopher Love money and drugs from a cartel to kill Hatcher. The getaway driver testified at the hitman's trial last October.
We started planning this murder. We would follow Miss Kendra. We would stake out her apartment.
Love was sentenced to death for his role in the killing, while the getaway driver agreed to a 35-year sentence to testify at both trials. But investigators say the real mastermind, Brenda Delgado, fled to Mexico. Months later, she was captured and extradited. In exchange, prosecutors agreed not to seek the death penalty. She faces life in prison if convicted for Hatcher's death. Watch gavel-to-gavel coverage on the Law&Crime network of this trial. I'm Rachel Stockman for Law&Crime.
And as we wait for the Jones case to come back, we are still following with the Kellen Winslow Jr. case. Now, it's a case that asks the question, serial rapist, former football star, is he smeared by false allegations or just a money grab by the alleged victims trying to get their 15 minutes of fame? We have 5 alleged victims, 3 of them saying that they were raped by Kellen Winslow and 2 saying there was indecent exposure. We have our very own Rachel Stockman with the update of that very case.
Kellen Winslow is a man who has been given much, but it was not enough.
In opening statements, prosecutors tried to paint a portrait of defendant Kellen Winslow as a privileged superstar, repeating the theme that his fame and fortune were never enough.
Instead, he took from these women.
Prosecutor Dan Owens gave graphic accounts of Winslow allegedly threatening his victims as he raped them.
As the defendant's attitude changed, he then told her, "I'm going to fuck you, and if you say anything, I will kill you."
The state's case rests largely on the words of the accusers. The defense attacked the accusers as opportunistic liars.
Those accusers aren't giving you the whole truth.
The defense said consensual encounters have morphed into rape accusations because of Winslow's stature.
Jane Doe 1 is charged with kidnapping her. She wanted to get into his car, and they have oral sex. Per her original statement, it was not forced. She left that part out of her statement.
Defense attorney Brian Watkins delivered parts of his opening statements with his hands on the shoulders of his client.
When you're in the spotlight, people want things from you.
While the prosecution spoke for about an hour, the defense's opening lasted only 15 minutes. For the Law&Crime Network, I'm Rachel Stockman.
Welcome back. Now we're joined with a good friend of mine, Adam Heyman, probably one of the greatest defense attorneys I've had the pleasure of seeing doing a summation. Adam, welcome.
Thank you so much for having me, Brian. It's great to be here with you.
Absolutely. So as we're following this Kellen Winslow Jr. case and just Jane Doe after Jane Doe after Jane Doe is testifying, what are you seeing is going to be the struggle for the defense attorneys here?
I mean, it's pretty obvious, right? Each case in and of itself is a trial, right? I mean, we have a rape, public exposure, and to tack these charges on one after another is a really, really tough obstacle for the defense to overcome. And you know, you and I have talked about this before, but if you can't win that motion to sever these charges and a jury gets to hear all of these charges from different women, it's very hard as a juror, I think, to give him the benefit of the doubt in this case.
Yeah, and speaking of all the Jane Does, we actually have the testimony from Jane Doe number 5. Now to recap for our viewers, this is the Jane Doe who's accusing Kellen Winslow Jr. of decently exposing himself in the Crunch Fitness gym. Let's take a look to what she had to say. So there you have Jane Doe number 5 recounting the incident. Now, Adam, as I'm listening to this, sometimes when we have trials, we have the benefit as defense attorneys that the alleged victim has to recount something months, years ago. This just happened in February. It's fresh in her mind.
It is fresh in her mind, right? So you could argue that she's remembering this thing well, but at the same time, I mean, let's just thinking about it. On February 13th of 2019, she said this incident happened in the gym. She doesn't report it to anybody. Now, he was at that gym every single day working out. I have a very hard time believing that she didn't know who this guy was. There are no witnesses who saw this. Apparently, while there were cameras in the gym, the cameras for this part of the area wasn't working. There's still doubt to be cast despite the fact that it happened so long ago. So while she's testifying about something that allegedly occurred just a few months ago, at the same time, I think there's some real issues with this case. But like we've talked about before, Brian, if this were just a trial, this would be a very, so there'd be a lot of game in this trial as a defense team to challenge her credibility, as you mentioned before, a money grab. But when there's so many other people who are also saying that he did things as well, it makes the obstacle a lot more difficult.
Yeah, it seems like the battle, to me at least, here is you have individual women who are telling stories where you can probably find a couple points of reasonable doubt, like you're letting out. It's a gym. I think on the 13th, that's a Wednesday, and the 22nd, that's a Friday. Where is everyone else? Who else is seeing this? It paints the picture of a man walking around the gym with an erect penis. You would think there'd be a lot more cause for alarm than what she's depicting.
Right. You would think she would say something, and also in the context of the money grab, we don't get to see Jane Doe number 5. We have a picture of her here. Look at all the gold she's wearing. I mean, this seems to me, if I'm a prosecutor, I'm telling this woman not to wear all of her, bling. I would have her be way more subdued in terms of the jewelry she's wearing, because here they say on a Wednesday he exposes his penis in the gym. Not a single person hears about it. She doesn't respond to anybody. She doesn't say anything. And then it's 9 days later in the jacuzzi that she says that he's masturbating, even though she technically says, I never actually saw him masturbating because there was too much foam. So I agree with you, Brian. There is a lot of reasonable doubt with respect to this case in and of itself. But again, I keep harking back to this point. You add on 4 other people's allegations against this guy, and it makes things a lot harder to believe.
Yeah, and let's actually listen to the testimony she gave about the second incident that Adam's referring to, about what she believes she saw or what she did see in the whirlpool. So interesting, as we were listening to this Jane Doe talking, Adam and I were actually talking about the different ways that this can cut. Adam, I can see in one sense, and I agree with you, once these cases were joined, it became an uphill battle that I can't even imagine he climbs out of. But it appears that, and I think the prosecutor's gonna argue, this is his MO. Older women, transient women, this is who he goes after. But you made a good point that it's maybe a little too similar.
There seems to be a couple of MOs, right? If we're going to try to argue, modus operandi, that's what you're saying when you refer to MO. He seems to be someone who, has this tendency, as the prosecutor wants to argue, to expose himself to people in public, but then also to bring people inside his cars and go to a private place. Those are the homeless transient women. But you could just see Kellen there listening to Jane Doe number 5 talking about the jacuzzi incident. And she was talking about how, I wrote her words down, feel water coming onto my side. Well, that's what you feel when you're in a jacuzzi. You could see him sort of reacting to this. And one of the things I wonder in this case, and we won't know until the prosecutor rests, is Kellen going to testify? Because if Kellen testifies, this really changes and attacks the MO that you're referring to here, that he is just this person who has this impulse control issue, who can't control himself. Can you imagine if you're out on $2 million bail, you're a famous person in the community, you played in the NFL, you're going to a public place, the Crunch Gym, and you're just going to decide to expose yourself to a 77-year-old and just risk it. It seems like not only is his MO to expose himself allegedly and to allegedly rape transient folks, but it's also to just do these brazen public acts while he's already out on bail and on skating on such thin ice.
Yeah, and as you're describing it, this is the first time I'm thinking about it, you can't have it both ways. It seems that on one aspect, the prosecution is going to say, he's this person that goes to communities where it can be private, you're not going to know, like they're in shelters, they're transient, and then takes him to the secluded area and then rapes him. But also, his thing is to do things very much in the public. And it's like, at some point you lose credibility with that.
Right, and you know what? There could be an impact with the prosecutors trying to tack on so many charges. They could, if I'm the defense attorney in this case, I'm going to say these prosecutors are so desperate that they're going to take, look at him right there reacting to this all. They're so desperate, they're going to throw any charge whatsoever. And some of the charges, like you said, kind of smack in the face of what his motive is on the more serious charges that carry life in prison. So it's a very complicated set of facts, but like you and I have been talking about, each one on its own is pretty, attackable. And there are a lot of issues and reasonable doubts in this case that I think, if the defense does a good job, can exploit in an effective way.
Man, I cannot wait for this summation on both sides. I think it's going to be truly spectacular as to how they walk that tightrope. Consensual, not. Allegations that the blood that came from her was due to the rape. Now it's a menstrual cycle. Adam, as we go through this case and Jane Doe number one's allegations go from harsh to benign to maybe not, it seems like the same thing. Individually, the cases seem somewhat weak, but altogether, I'm not sure.
One of the things that everybody's been talking about is the fact that she didn't identify him. In fact, she identified his attorney, and this happens occasionally, but this is not an identification case. They're not arguing that he had an alibi, that he was somewhere else. They're actually arguing consent. So the fact that she wasn't able to pick him out maybe goes a little bit to her credibility, but they're not saying that he wasn't there. Here is the issue with this case, right? There are no witnesses. There is no injury. You can explain the blood through the menstruation here. But the problem is that I think as jurors, they're going to think to themselves, why on earth is this guy who's married, who has apparently a lot of things going for him, he's a successful guy, his father was a successful Hall of Fame NFL, why is he picking up a transient person, a homeless person, and having sex with her? And that is just a hard thing to talk about as a defense attorney. But in their opening, it was short, it was only a few minutes long, but they said, hey, listen, don't judge him for the acts that he did here. He's arguing consent with respect to Jane Doe number one. However, it's not illegal to have sex with someone. But Brian, we were talking about how each Jane Doe kind of affects the other. They're arguing consent on this one, but they're not going to be arguing consent on the kind of the public lewdness, public exposure charges. So it gets a little bit complicated when you have so many of these Jane Does here, but it's also a really good first Jane Doe case when there are no injuries, there are no witnesses. You can argue the money grab that the defense is arguing, and then he uses a totally different name than he's been using with the other Jane Does. It's Dominique with Jane Doe number one, it's Kevin with Jane Doe number two, it's David with Jane Doe number three. He has to be a pretty smooth operator to be coming up with completely different names for all of these allegations.
So I know we always bounce back and forth as to whether or not the defendant's going to testify. And usually I hesitate and I say, you know what, don't do it, because I'm always fearful of cross-examination. But I think for a case like this, there's an argument that it might need to happen, that he needs to take the stand and kind of swallow that poison pill and say, I'm a dog. I've got a family, I've got a home, I've got a good environment back there, but I'm a straight up dog. And I sometimes go on the streets and I meet other women and I do it in a community that will never come in contact with my community. That's where I'm wrong, but I never raped these people. I never did this. I think that's almost needed in this type of case.
Yeah, I'm so sorry for what I did, guys. I really, I made a mistake, but I promise you I did not force this woman to have sex with me. Something like that, I think, would go a long way. At the same time, like you said, you put your client on the witness stand, you expose him to cross-examination, but as far as I understand, he doesn't have any prior criminal record for this kind of thing, so they can't sort of, impeach his credibility in that sense. I mean, but look, if he doesn't get on the witness stand, despite the judge's instructions that you can't hold it against him if he doesn't testify, I have a hard time believing that these jurors aren't going to hold it against him. When we do jury selection, Brian, you and I, we always talk to jurors about whether or not they're going to be able to follow the law with the judge's instructions about whether you can hold the law and follow it, about whether you're going to hold it against the client if he doesn't testify or not. And in this case, I'm sure they did a lot of that. But at the same time, I have a hard time believing that they're not going to hold it against him if he doesn't get up there and say something.
Yeah. I think that there's going to be a blurred line between what he did was morally wrong and the question of whether or not it was legally wrong. We're going to continue recapping this case and more after this break.